Imagine a weapon that is just, so powerful, it can take total control of your smartphone without you ever tapping a single link or even opening a message.
Right, zero user interaction.
Exactly. Now imagine a foreign intelligence agency buying that weapon, and not in, like, some secret midnight meeting on a foggy bridge, but through a basic LLC registered to a perfectly normal suburban house in Virginia.
Which is just wild to think about.
It really is. Today we are doing a deep dive into a $460 million federal lawsuit that completely exposes how modern espionage actually works.
Yeah, it is the absolute definition of hiding in plain sight. I mean, we're moving completely away from that cinematic James Bond aesthetic,
Yeah, totally.
And we're stepping into the really muddy waters of bureaucratic intelligence. It's this landscape defined by paperwork, shell companies, and PDF court filings.
So we have a stack of really fascinating sources in front of us today for this deep dive.
Yeah.
Primarily, we're looking at a 28-page federal civil complaint. This was filed in the Southern District of New York on February 27, 2026.
Right. Very recent.
Yeah. And we also have some incredibly revealing excerpted deposition transcripts from January 2025.
Those are eye-opening.
Oh, absolutely. And the mission today is to pull apart these documents and just understand how a business deal over highly advanced smartphone surveillance tech somehow morphed into allegations of international espionage.
And unregistered foreign agents.
Right, and the literal weaponization of the U.S. legal system.
Which really redefines what a weapon even looks like in the 21st century. And, well, more importantly, how those weapons are procured in the first place.
Yeah.
Because to understand the gravity of this lawsuit, we really have to start the genesis of the deal.
Yeah.
So the documents introduce us to this individual named Afan Sherwani.
Okay.
He is the sole owner of a Virginia-based company called ASO LLC.
Well,
And in the fall of 2022, according to his deposition, he reaches out to a New York businessman named Ben Jamil.
who operates companies called HSS Development Group and Cyber Communications, right? Okay, let's unpack this, because reading through Sherwani's deposition is just wild. He admits he is essentially a one-man shop.
Yeah, just him.
Right. He moved to the U.S. in 2017 after winning a visa lottery, sets up this LLC, and claims to do, quote, technical consultation. But he is looking for something highly specific.
Very specific.
He tells Jamil he needs technology capable of intercepting both iOS and Android devices. And for you listening right now, you really need to care about this. You use a smartphone every single day.
We all do.
Exactly. And this case just completely pulls back the curtain on this multi-billion-dollar, highly secretive market for what is called zero-click software.
Which is basically the holy grail of cyber surveillance. Sherwani testifies that a government contact, specifically the IT manager for the Kurdish Regional Government.
The KRG.
Right, the KRG. A man he refers to as Mr. Barzani had basically asked him to find this capability.
Okay.
And so this leads to a meeting in New York in December 2022, where Jamil pitches the Intellis zero-click cyber surveillance system.
I want to pause here for a second, because the mechanism of this technology is genuinely terrifying, and I think people often misunderstand it.
Yeah, they confuse it with normal malware.
Right. When most of us hear spyware, we think of those, like, obvious scam emails or texts.
Don't click the link.
Exactly. But a phishing email is just a con artist tricking you into unlocking your front door. Zero-click technology is entirely different.
It really is.
It's like a burglar who found a microscopic structural flaw in the blueprint of your house. A flaw that the original builder didn't even know existed.
That's a great way to put it.
Right. They just slip through the concrete foundation without ever touching the locks, bypassing the alarm system, and they're rifling through your filing cabinets without you ever even knowing they were on your property.
That is exactly the threat level we are dealing with here. It exploits zero-day vulnerabilities in the background processes of a phone.
So, like, without the user doing anything?
Nothing. Your phone might just receive an invisible text message or, like, a silent missed call, and the operating system just processes that data in the background like it normally would.
Wow.
But in that fraction of a second, the software takes total root control of the device. It requires zero user interaction.
That is wild.
And acquiring this level of intrusion, it is not cheap. According to the Memorandum of Understanding they signed, Jamil's group required a $60,000 upfront payment just to coordinate a live demonstration.
Just for the demo.
Just to show it worked.
But wait, how do you even safely demonstrate a weaponized exploit like this? Like, does Jamil just email them a zip file and ask them to test it out?
Oh, not at all. No, the logistics are incredibly tight. To prove the tech worked, they had to fly out a 5-person technical team.
Okay.
And this included developers from a specialized South African company called Admitech.
Admitech, right?
Yeah. So they are flying this entire team all the way to Erbil, Kurdistan. And Sherwani testifies he even had to set up this dedicated 1 gigabyte internet connection at the location just for this demo to function properly.
That is a massive operation just for a sales pitch.
Yeah.
The total value of this contract, if the demo succeeds, is over $10.7 million.
Right. Over 10 mil.
Which immediately makes me wonder, wait, who exactly is Sherwani, and why does his Solotech Consulting LLC have $10 million in capital to drop on military-grade spyware?
Well, if we connect this to the bigger picture, that is the exact question the lawsuit attempts to answer. And it basically pivots the entire narrative from a simple tech transaction to this massive allegation of international espionage.
Okay, so what does the complaint say?
The federal complaint alleges that ASO LLC is not a legitimate tech consulting firm at all. It claims ASO is a shell company.
Oh, wow.
Yeah. It is allegedly a front operating out of that residential home in McLean, Virginia, acting on behalf of the Kurdish Regional Government, and specifically the powerful Barzani family.
Right. The lawsuit specifically names Masroor Barzani and Wazi Barzani as the ultimate beneficiaries.
Exactly.
It even claims that Sherwani, alongside another defendant named Khosrow Wazem, who, by the way, is referred to in these WhatsApp messages as the general.
Which is very subtle.
Very.
Yeah.
But the lawsuit claims they are actually foreign spies. The complaint literally describes Wazman as a spy chief for the KRG.
And this is where the legal architecture of the lawsuit just gets incredibly dense and very, very serious. Because the suit isn't just targeting these alleged foreign agents.
Right.
It is targeting their United States-based lawyers, specifically attorneys Jonathan Moore, Theodore Kittela, Jeffrey Grielsheimer, and their law firm.
Okay.
The lawsuit alleges these American lawyers failed to register under FARA, the Foreign Agents Registration Act, and violated the Foreign Corrupt Practices Act, or the FCPA.
Wait, hold on. If I hire a lawyer to defend me in court, they aren't suddenly my agent. It's literally their job.
Right, right. So how does a civil plaintiff justify targeting American lawyers just for having foreign clients? Like, wait, aren't lawyers allowed to represent foreign clients in court without being labeled foreign agents? Where exactly is the line drawn between normal legal defense and illegal, unregistered lobbying?
That is the pivotal legal tension in this entire document.
Yeah.
So FRA was designed for transparency, so the U.S. government knows exactly who is lobbying or acting on behalf of foreign powers within our borders.
Makes sense.
Now, you're correct. There is an explicit exemption in FRA for bona fide, routine legal representation in a court of law.
Okay.
A lawyer defending a foreign national in a lawsuit absolutely does not need to register as a foreign agent. However, the lawsuit argues these attorneys sprinted way past that line.
Okay, so what takes a lawyer from being a legal defender to an unregistered proxy?
The mechanics of their daily tasks.
Yeah.
The complaint alleges that the lawyers knew ASO LLC was a sham entity designed solely to conceal the KRG's involvement and basically circumvent U.S. laws.
Wow. Okay. Furthermore, it alleges one of the lawyers, Jonathan Moore, had been doing financial services for the Barzanis for almost 20 years.
Financial services.
Yeah, we are talking about paying their credit cards and opening bank accounts.
Wait, really? Paying their credit cards?
Yes. And that is not routine legal defense. When an attorney handles personal finances and sets up corporate structures just to obscure the identity of a foreign principal, the suit argues they are actively advancing foreign political interests.
Ah, I see.
And that strips away the legal exemption and triggers the strict FARA registration requirement.
So the allegation is that they were using their law licenses and, the presumption of routine legal work as a shield to do the administrative bidding of a foreign intelligence operation on U.S. soil.
Precisely.
That is staggering. Yeah. And what were they allegedly trying to cover up with all these shell companies? Well, that takes us back to Erbil, Kurdistan, for the actual demonstration of this zero-click tech.
Right. Remember the South African team from Admitech that was flown in?
Yeah, the 5-person team.
According to the complaint, the demonstration turned incredibly chaotic. The lawsuit alleges that during the demo, KRG officials realized the immense power of a specific piece of the technology known as the gatekeeper protocol.
Okay.
And they actively tried to physically steal it.
Physically steal it?
Yes. The developer from Admitech, a man named Rain Knox, claimed he had to change hotels 3 times in Erbil because he was receiving threats to his safety.
Oh, my God. Right, and here's where it gets really interesting. Because they see this gatekeeper protocol in action realize its power, and decide they don't want to just, rent it from Jamil. They want to own it entirely.
They want the keys to the castle.
Exactly.
Yeah.
The lawsuit claims Sherwani, the Barzanis, and the general bypassed Jamil completely. They went straight to the South African developers at Admintech and cut a secret side deal.
And they allegedly demanded $360,000 in unlawful kickbacks in the process.
Wow.
Those alleged kickbacks are the specific mechanism that triggers the Foreign Corrupt Practices Act allegations in the suit.
So it's essentially like paying a real estate broker to show you a highly exclusive house. And while you're at the open house, you secretly steal a spare set of keys.
Right.
Then you track down the original builder of the house and bribe them so you can cut the broker out completely and just take control of the property yourself.
That is a perfect way to visualize the breach of contract. And the financial fallout for Jamil was astronomical here.
I bet.
The complaint states he had an established agreement that would have given him a 51% share of a new company owning this intellectual property.
Okay, so a majority stake.
Yeah. And because of this alleged tortious interference, Jamil claims he lost out on $450 million in potential global revenue.
$450 million. That is insane.
To put that massive number in perspective, the complaint cites a Carnegie Endowment report that values the broader global zero-click surveillance industry at a staggering $12 billion.
$12 billion. That's an ocean of money, which absolutely explains why the stakes are so high and why people are allegedly willing to threaten developers and hotels. But I have a huge structural question here. If Jamil got cut out so blatantly overseas, like in Kurdistan and South Africa, how did a breach of contract on the other side of the planet turn into a brutal $460 million federal lawsuit filed in the state of New York?
Well, because Jamil didn't just walk away and accept the loss, he tried to fight back.
Right.
He started sharing his case files, the deposition exhibits, and his evidence with various U.S. lawyers, trying to retain domestic counsel to go after the defendants.
Makes sense.
And when the defendants realized he was actively building a case against them, the lawsuit alleges they weaponized the American justice system itself to silence him.
And when you say weaponized, you aren't speaking metaphorically.
Yeah.
Because I am looking at Exhibit A from the source text.
It's intense.
It's an official court order from the Commercial Division of the Supreme Court of New York in Westchester County. The defendant's U.S. lawyers filed an order to show cause to hold Ben Jamil in criminal contempt. The document literally has a warning printed in bold all caps that says, "Your failure to appear in court may result in your immediate arrest and imprisonment."
Yeah, what's fascinating here is the specific legal mechanism Jamil is using to strike back against that threat in this federal complaint.
Okay.
He is suing them under 42 U.S. Code Section 1983, claiming a deprivation of his civil rights under color of state law.
Wait, usually you only see Section 1983 used to sue police officers or prison guards or mayors, actual state officials who abuse their government power?
Right, state actors.
So how does a law meant to police the government apply to private attorneys who are just filing paperwork in a commercial dispute?
Well, it comes down to the state's monopoly on violence, which includes the power to put someone in a jail cell. A private citizen cannot throw you in jail.
Obviously not.
But a judge can.
Ah.
By improperly invoking a judge's criminal contempt power, which carries the literal threat of state-sanctioned imprisonment, these private attorneys effectively borrowed the coercive power of the state.
Oh.
Yeah. Jamil is arguing that because they wielded that state power purely as an intimidation tactic on behalf of a foreign client, they transformed themselves into state actors operating under color of state law.
To intentionally intimidate a witness. Because the complaint points out that the Barzani family and these same defendants are already facing other massive federal lawsuits in Washington, D.C. and Delaware.
Yes, entirely separate cases.
Right. And we are talking about severe allegations involving terrorism funding, money laundering, and human rights abuses.
Serious charges.
So the claim is that this criminal contempt charge over a simple contract dispute was actually a mechanism of civil extortion. They basically wanted to throw Jamil in a New York jail cell so he couldn't testify or provide evidence in those other federal cases.
It is a textbook definition of abuse of process.
Yeah.
The legal system allows for contempt motions to enforce court orders, sure.
Right.
But they allegedly used this legitimate legal tool for an entirely illegitimate collateral purpose, to permanently silence a witness who posed a threat to a foreign government's broader interests in the U.S.
Unbelievable.
In fact, there are WhatsApp messages heavily referenced in the complaint, where the defendants allegedly tell Jamil all will be forgotten and they will drop the criminal contempt charges entirely.
If he just hands over the tech demonstrations right before the
Right.
court date, right?
Exactly.
But wait, are the lawyers just pawns in this? It sounds incredibly risky for established U.S. lawyers to jeopardize their entire careers, face potential disbarment, or even criminal charges over a foreign client's vendetta.
It does.
Is the lawsuit arguing these lawyers didn't know ASO LLC was a spy front, and they thought they were just aggressively representing a tech client, or that they were active, knowing co-conspirators in this extortion?
This raises an important question about legal culpability, and the complaint is unequivocal on this point. It does not allege the lawyers were duped.
Oh.
No, it alleges they had full, comprehensive knowledge and were active, willing co-conspirators. The suit claims the attorneys knew ASO was a front, knew the true beneficial owners were foreign principals, and deliberately pursued these criminal contempt proceedings to advance a fraudulent scheme and protect the Barzanis from federal scrutiny.
But wait, doesn't attorney-client privilege protect everything the lawyers and the clients discussed? Like, how can Jamil even probe into what the lawyers knew?
Through a massive legal mechanism called the crime-fraud exception.
Okay, what is that?
So attorney-client privilege is a bedrock of the legal system. You need to be able to speak candidly with your lawyer so they can defend you for things that happened in the past.
Right.
But that privilege instantly vanishes if a client uses the lawyer's advice to plan a future crime or a future fraud.
Oh, that makes sense.
The complaint specifically invokes this exception. It argues that because the lawyers and clients were actively colluding to commit extortion and evade a FARA registration in real time, the shield of privilege does not apply. The court can pierce that veil and examine the communications because the legal representation itself was allegedly part of the ongoing criminal enterprise.
So what does this all mean? Like, we are looking at a scenario where a foreign entity allegedly attempts to buy ghost-like surveillance tech.
Right.
Physically tries to steal it.
Yeah.
Cuts out the American broker,
Mm-hmm.
and then uses American lawyers to threaten the American broker with jail time in an American court to cover the entire operation up.
That is the mechanical essence of the $460 million claim. And, we must absolutely emphasize to the listener, we are impartially reporting the contents of this federal complaint and the attached depositions.
Yes, absolutely.
We are not taking political sides, and these are, at this stage in the judicial process, allegations filed by the plaintiff.
Right, these are allegations.
But the sheer mechanics outlined in these documents highlight a massive evolution in how global conflict operates today.
It's the concept of lawfare, right? The idea that the justice system itself can be weaponized as a strategic tool of conflict.
Precisely. The modern battlefield isn't just physical anymore. It isn't just kinetic warfare.
Right.
It is fought with zero-click spyware that exploits silent vulnerabilities in code. It's fought through shell LLCs registered to quiet suburban houses in Virginia. And it is fought through weaponized civil litigation in commercial courts in Westchester County, New York. The United States legal system has literally become a secondary battlefield for foreign intelligence.
It is entirely chilling because it is so mundane on the surface. So, the next time you picture international espionage, don't look for the trench coat in the shadows. Look for the routine legal filing in a state commercial court.
Because that dry, bureaucratic paperwork might just be the operational cover for a multi-billion-dollar intelligence operation.
And that leaves us with one final, incredibly provocative thought to mull over. If a foreign intelligence agency can allegedly use a basic LLC registered to a suburban house to attempt to acquire military-grade cyber weapons, and then turn around and use our own U.S. court system to punish the person who sold it to them, what does that actually say about the guardrails protecting our technology and our justice system? Like, if the front door is this wide open, who is actually vetting the true buyers of our most dangerous digital tools?